Hello, everyone. I'm Victor Manibo, and welcome to the AM Show, Wang Law Office's question and answer show.
Hi, my name is Ariel. I'm the host, also a senior paralegal at Wechat Office. Our show going to start every Friday at 11 a.m. EST, 8 a.m. PST.
Here at the AM Show, Ariel and I try to answer your most pressing immigration questions. We get questions from our viewers through our platforms like Line, YouTube, through email, and we collect them all into one weekly topic. Today's topic is a continuation from last week. We started talking about removal orders and how to deal with them, how to get rid of them, what your options are if you already have a removal order. And because this is such a big and important topic, we had to cut it into two parts. Today is part 2. So if you missed part 1, go back and watch that. And then today we're going to talk more about other options for people who have removal orders.
Yes, before we start the topic, Victor, can you tell me a little bit about your background?
Sure. For those who haven't met me yet, again, my name is Victor Manibo. I'm a senior attorney here at Wang Law Office. I've been with the firm for over 10 years, and I've been a lawyer for over 12 years. I'm licensed to practice in New York and New Jersey. However, because we are an immigration law firm and immigration is federal law, our firm is able to serve clients anywhere they are in the United States. I graduated from Cardozo School of Law in 2010. Most of what I do here at Wang Law Office is immigration litigation, meaning I help non-citizens and defend them in immigration court so that they don't get deported, so they don't get the removal orders that we're talking about today. I also do immigration applications, meaning I help non-citizens apply for status with our various immigration agencies. Aside from being an attorney, I'm also a writer. I came out with a science fiction novel last year called The Sleepless.
So back to today's topic. Last week we talked about the motion to reopen if you have a removal order or deportation order. We are going to talk about other way that you can deal with or get rid of the order.
Right. So last week we talked about motions to reopen. We also talked about joint motions to reopen and a little bit about BIA appeals and circuit appeals. And if you'll notice, most of that has something to do with the court, with EOIR, or the Executive Office of Immigration Review, our immigration court system. They're the ones who issue the removal orders. So they're the ones who kind of are the first thing that we think of, like, oh, okay, if we want to get rid of the order, we have to go back to court. We have to file a joint motion to reopen or a motion to reopen or appeal or anything like that, right? But today we're going to talk about other ways of dealing with removal orders, because you might be able to get status even though you don't, even though you have a removal order, or you might get another way of dealing with or getting rid of your removal order, not through our court system, but through USCIS.
So I know that there is a waiver. I-212 can help with this matter, right?
Yes, exactly. USCIS is a venue by which a non-citizen who has a removal order might be able to get some relief from removal orders. The first one is the I-212 waiver. It's a waiver for the effects of having a removal order. Basically, you're asking USCIS to forgive the fact that you have a removal order. This waiver is one of our hardship waivers. This is similar to the unlawful presence waiver or the fraud waiver, and we have YouTube videos about each of these types of waivers, right? But the common thread about all of this is hardship.
So there is a situation that someone came into US without a status and then later on get the deportation order, but he also have a US citizen relative. In fact, he have a proof I-130 by the US citizen civilly after he waited for a long time, and then the parent came to the US with green card. So can he get any kind of waiver?
Right. So this is the perfect situation for an I-212 waiver. This is a person who has a removal order, has the I-130 approved already. They have a U.S. citizen relative who applied an I-130 and then petitioned for them, and the petition got approved, right? And they also have U.S. citizen parents. This is one of the requirements for the I-212 waiver, for the waiver of the removal order, you have to have a U.S. citizen spouse or U.S. citizen parent or LPR spouse or LPR parent who will suffer hardship. If you can prove that, and you might be granted the I-212 waiver, which waives the effects of your removal order. However, for this particular case, this particular client, the removal order is just one of his problems. The other problem is the unlawful presence. This person entered without inspection, also stayed in the country after he got the removal order, so he's dealing with unlawful presence. He also had to do the unlawful presence waiver after the I-212. He had to do that sequentially, and luckily we were able to do both successfully for this client.
Some people want to know that if we only do one waiver, maybe the 212 waive the deportation order, can they still get a green card?
Well, no. The I-212 waiver isn't going to let you just get a green card right away automatically. It's not going to let you adjust status or, wait in the United States for a green card, right? The 212 is really a way or a path for someone to get a green card through the I-601A and consular processing process. We've differentiated these two pathways in previous YouTube shows. But basically, one way of getting a green card is through adjustment of status. If you're already here in the United States, you apply for it with USCIS. But if you're already here in the United States and you have an order and you have unlawful presence and you have to file these waivers, this 212 and I-601A waivers, you can't adjust status with USCIS. You have to go back to your home country, go through consular processing there, and then come back with your green card, hopefully approved by the consulate. And so that's the process. If you have a 212, even if it gets approved, doesn't mean that you can just adjust status.
So in another situation, someone live in Texas and have the deportation order with the U.S. citizen wife, and this wife petitioned him for the I-130. Is there other way for him to get status?
So for this situation, right, this person has an order, has unlawful presence, has an I-130 approved, has a U.S. citizen spouse. They have an order. They have basically two pathways to them. They can either ask for an MTR, or do an I-212. Both ways are ways of dealing with the removal order, ways of getting rid of the removal order. You could do the I-212 with USCIS, or you could do the MTR with Immigration Court. With this client, we did an MTR. We went back to the court and showed them the I-130 approval and said, hey, this person has a U.S. citizen wife already approved by USCIS, the I-130, and now they can do I-601A and consular processing out of the country. Please, let's get rid of this removal order. And we got that successfully granted. Got the MTR approved or granted. We got the removal order terminated, which allows this person to then do the I-601A consular processing just fine.
So is there other way to get status that doesn't care about if you have a deportation order or removal order?
So we're staying with USCIS, right? We're looking at options for either dealing with your removal order or getting status without having to deal with your removal order. And now we're moving on to U visas, which is a very special kind of visa. We've talked about this in a previous YouTube episode. And one of the ways that this is special is you can apply for it even though you have a removal order. One of the biggest consequences of the removal order, aside from being targeted for arrest, is that you can't apply for status. Generally, you can't have an easy way to get any sort of legal status. However, U visa, you can get it even though you have a removal order. And you also have a pathway to a green card.
So after we're getting the U visa, or maybe in the process of applying for U visa, can we help our family member to get it?
Yes. So the U visa is a non-immigrant visa for crime victims and their family members. So if you're a crime victim, if you qualify, you can also add your spouses and minor children to your application, and they will have U status as well.
So if we apply for the U visa, can we get a EAD card?
Yes. So usually you can only work in the United States once your status is approved. Another way that the U visa is special is that it allows for you to get employment authorization even though your application is still pending and not yet approved. USCIS very recently implemented the bona fide determination program where they look at the U visa applications that are pending and determine which are bona fide, and if you get this determination, you will be given an EAD document, which allows you to work while you wait for your U visa to be approved. And this is important because U visas right now are so backlogged. It's taking more than 5 years, in some cases 10 years. And you can't wait that long without working. That's why we have this BFD program. That's why, again, U visa is kind of special because it lets you get this even though your application is just pending.
So let's get to the main point. What are the requirements for U visa?
For U visa, there are 3 main requirements. We go through them in detail in our previous YouTube. Please go check that out. But in general, the first is that you are a victim of a qualifying crime. Not all crime victims qualify for a U visa, only those that are victims of specific crimes listed in the statute. It's a long list. It's mostly serious crimes. But if your crime is not on that list, you're not eligible. If it is, then you're eligible. The second requirement is that you suffer substantial injury. This injury can be physical, like literally on your body, or mental, psychological, emotional, as long as it's serious as a result of the crime. So you were victimized and you got this serious injury. The third requirement is that you're able to show cooperation with law enforcement or prosecution in the investigation and prosecution of the crime in which you are a victim. So you have to basically get the police or the prosecutor to certify, to sign a document saying that you reported the crime, you helped them to go after the people who attacked you or who victimized you.
So is that easy to get that certification?
Well, that really depends. Our firm has had a good track record getting certifications for our clients, but clients are always, or prospectus are always thinking, oh, it might be hard to get a police officer or a prosecutor to sign this. Why do they care about me, right? And it's our job to convince them to sign, especially, you're a crime victim. They're supposed to be helping you because you just helped them, right? So in general, so far we've been successful and we've been lucky to work with police officers and prosecutors who want to sign. And in some places, there are actual laws that require police officers and prosecutors to cooperate and sign these sub-B certifications. Like in California, there was a law that was initiated in 2015 and implemented in 2016 saying, hey, if you have a crime victim who helped you out and needs the sub-B, if you're a police officer or prosecutor, you should sign it. You should help them out too.
So there's an old client that he was arrested because EWI, and then later on before his criminal case finished, he just immediately transferred to the ICE detention. So there is a way to get him out, right?
So we got this person out through U visa, actually. Let's break it down. This person was arrested by state cops because of a DWI. And then this person has an order, which means the cops were like, oh, we are going to transfer you to immigration because you have a removal order and you should be kicked out of the country. So they transfer him to immigration, right? And because of that removal order, which is why we have this entire topic. Removal orders are a big problem. If you get arrested, even for like a DUI, you can get transferred to ICE and then you're detained by ICE. Then what are you going to do, right? For this one, we use the magic of U visa. Again, U visa is something that a person can apply for with USCIS even though they have a removal order. What we did in this case is we discovered, oh, you are eligible for a U visa. Let's apply to USCIS right away. Let's expedite that application. And then when we got that approved, then he got status. if you have status, ICE can't remove you anymore. And that's how we got him released. We told ICE, we got him used status. He now has legal authority to stay and live in this country. You have to release him. You can't hold him anymore. His removal order is effectively useless. And that's what happened here.
When we often talk about U visa, we also think about T visa. T visa also, we can apply for it. Doesn't care about if you have a deportation order or removal order, right?
Yes, T visa, we always talk about it kind of similar to U visa. It's also a crime victim visa, but it's very specific to victims of human trafficking. And like the U visa, it doesn't matter if you have a removal order. You don't have to worry about that. You can apply for it with USCIS even though you have a removal order, and it also has a pathway to a green card.
So I can also apply for the family, help them to get status, right?
Yes, like the U visa, the T visa will also allow you to add your spouse or minor children to your application.
So what are the requirements for T visa?
For T visa, it's a little similar to U visa. There are 3 main requirements. If you want to know more about the specifics of these requirements, please check out our previous YouTube shows. But the first one is you have to be the victim of human trafficking. Human trafficking is a very specifically defined crime in our immigration statutes. And, every state might have a different definition of human trafficking. There's a federal definition of human trafficking. The crime that you were a victim of has to fall under that definition. The second requirement is you have to show extreme hardship to yourself or injury to yourself. Again, the injury can be physical or mental. And the third requirement is you have to show that you helped law enforcement or prosecution in investigating and prosecuting the human trafficking crime in which you are a victim.
So besides UT visa, there is other way to get status that not care about if you have a deportation order or removal order, right?
Right. So there's actually a way for you to get a green card from USCIS even if you have a removal order, but that's only if you are an arriving alien. Arriving alien is a specific designation in our immigration laws. And if you are an arriving alien, it doesn't matter if you have a pending immigration court case, if you have a removal order, if you have a deportation order, exclusion order, it doesn't matter. You can still go to USCIS and apply for a green card through family-based petition, for example.
So what kind of situation you can apply for it? Do I have to have a US citizen parent, or can a sibling help me to get status in this situation?
Immediate relatives will have the easiest time as an arriving alien to apply for adjustment of status, because if you are the relative, or if you have an immediate relative petitioner, number one, you don't have to wait for a priority date. You don't have to deal with the unlawful presence ground of inadmissibility or unlawful employment ground of inadmissibility.
So back to the point, what is arriving alien?
Right. So what is an arriving alien is the first question, right? Arriving alien is generally those non-citizens who arrive at a port of entry, like an airport or a seaport or a border crossing, who present themselves to immigration officials to be allowed to enter, to be admitted into the country. These are usually the people who, present themselves at the border or the airport and get arrested because they don't have the right papers, they don't have the right passport or visas, and they're arrested, they're sent to immigration court, they're designated as arriving aliens. They didn't enter without inspection, they didn't enter illegally, right? Or they didn't overstay. These are people at the border, not officially admitted to the country yet. If you are one of these people, arrested at the airport, for example, sent to immigration court, your NTA, the notice to appear that starts your immigration court case, will say there, like, you are an arriving alien. If you are designated an arriving alien, even though you lose that immigration case later on and you have a removal order, you can still apply for adjustment of status with USCIS.
So after you getting the status from USCIS, then you deal with your order, right?
Yes, exactly. So what happens here is kind of the reverse. You get the status first, and then you get rid of your removal order. Last week, when we were talking about motions to reopen, we were saying you reopen your case, get rid of your removal order, and then you go to USCIS so that you can apply for status. If you're an arriving alien, it's the reverse. Because you can, you go to USCIS, you apply for adjustment of status, you get your green card. Once you have that green card in hand, you go to the immigration judge, show the immigration judge, hey, I have this green card now. Let's get rid of the removal order.
Yes, and this is very special. So besides this, there's another way to get status that does not care if you have an order, right?
Yes, it's the I-730 or the derivative asylee status. Asylum, we've talked about in the show before. It's very special. It is treated differently. There is a different process for asylum. And the same goes with asylee derivatives, the family members of people who are granted asylum. If you're granted asylum and you have a spouse or children that you didn't include in your original application, you can still petition for them. You can still get derivative asylee status for them by filing the I-730. And this is a status that you can seek with USCIS even though you have a removal order. So even though, let's say, your spouse has a removal order and you have asylee status, you can file an I-730 for your spouse. Doesn't matter that they have a removal order.
I remember that we have an old client who was detained because some sort of crime, and he got transferred after we tried to bail him out from the criminal court. But he got transferred to the immigration court, the ICE detention. But eventually, we still get him out, right?
Yes. So for this client, he was arrested on criminal charges. We bailed him out. Unfortunately, once we bailed him out, ICE picked him up because this is what they do. So they said, oh, you have a removal order. Okay, we're going to take you. We're going to detain you. We're going to prepare to put you on a plane. So now what are we going to do? We're going to have to help him. ICE didn't want him out. They didn't want to release him. So what we did was we found out that he was eligible as a derivative asylee through a relative. We filed the I-730. We expedited the I-730, so USCIS approved it quicker. And once it was approved, we were able to convince ICE to release him because, hey, he has status now. You can't release him anymore. You can't deport him anymore. So please let him go.
We mentioned some client who got detained before, and now we are being successful about them out. But you're going to have some new coming client that they want to know how we can bail the relative out.
Right. So, we've talked about these clients, they have removal orders, and there's a different solution to every person because every case is different. We keep saying that on this show, right? Every case is different. But we still get all these questions like, okay, my relative got detained. How am I going to get them out? Well, the answer is it depends. There are certain steps that you have to take that you have to know once your relative is detained or you are detained. So these are the tips that you need to keep in mind, right? Number one, if your relative is detained, usually you're not going to know what happened to them because ICE just gets them and then puts them somewhere you don't know. They don't tell you. They're not going to tell you. They're not obligated to tell you. So you can check the ICE detainee locator website. The link is on the PowerPoint on your screens. Go to that link and then enter the A number, the date of birth of your relative, and it will show you where they are located, where they're being held. So hopefully that'll help you get the process along in terms of knowing what happened, getting them in touch with an attorney who will help them to be released from custody.
People always ask, what kind of right we have when we are in detention or the relative is in detention?
One of the important things to know when you're detained is that you still have rights. You might have a removal order, but that doesn't mean that ICE can just do whatever they want with you. That doesn't mean that you have a removal order, they can just put you on a plane. It doesn't work that way. It's not that straightforward. And as you've seen with all these other clients that we've gotten released, there is always a way. There's always an option, right? So it's important to remember that you have rights. You have to remember that you have a right to an attorney. You have a right to communicate with your attorney. You have a right to have an interpreter if you don't speak English. ICE has to provide you with an interpreter. They have to explain everything to you in a language that you understand. They have to show you documents in a language that you understand. They also can't just detain you forever. Usually when they detain someone, it's because they're waiting for their opportunity to put the person on a plane. They need to get travel documents that will allow them to put this person on a plane and be picked up at the country where they're deporting the person from. They're called travel documents, and they need to get those documents first. But sometimes those travel documents take a while because they have to get it from a consulate or the embassy of the foreign government. And even if it takes forever, that doesn't mean that they can just hold you forever. There's a limited time during which they can hold you. Otherwise, it becomes unconstitutional because it's too long. And it is your right to be released and not be subjected to unreasonable, prolonged detention.
So even you are released from ICE, you are still need to report to ICE, right?
Well, yes and no. That depends. Again, one of the things that you need to do, or if you or your relative is arrested by ICE, is to get a lawyer to help get you out. Your lawyer can get you out the way we've done for these prior clients by applying for status, getting rid of the removal order altogether, right? But for some people, they are bailed out temporarily, bonded out temporarily. They might still have that removal order. The case isn't over yet. And if that's the case, they might have to report to ICE regularly, periodically, because ICE is still taking their steps to remove this person. It's just that you're not being held in detention. So it's really important to just completely get rid of the removal order so you don't have to worry about it. You don't have to report. You're never at risk of being arrested again.
So I remember there is a case that someone was arrested by the police and then later on transferred to ICE detention. So eventually we are being able to get her out. So how do we get her out?
Right. For this client that's on your screens right now, she was arrested because she was allegedly buying fake documents or fake green cards and then transferred to ICE. It was not really a very valid arrest or case, but she was transferred to ICE because she has a removal order. This is a mother of 2 young children, as you can see in the picture. She's had a family. She's been here for such a long time. And the way we got her out is we used the media to pressure ICE to release this mother, to say, hey, these are not the kinds of people that you should be kicking out of the country. And we were successful in doing that.
So in another case that someone got arrested because of a traffic violation and they found out they have all deportation order. So this case, we did successfully get him out.
Yes, and this is a slightly different method from the last one that we talked about, right? This person got stopped for a traffic ticket, and then they have a removal order, and then they were transferred to ICE and detained at ICE. This is why removal orders are such a headache. It's just a traffic ticket, and then you're in jail. That's why you have to deal with your removal orders. But for this person, already had the removal order transferred to ICE. What we did was we convinced ICE to exercise prosecutorial discretion to release this person because he just had a traffic ticket. Why are you deporting him out of the country? This person had a family, had been in the country for such a long time. And ICE, especially after the recent prosecutorial discretion memo, they have priorities of the kinds of people that they're supposed to be deporting. They're supposed to be deporting terrorists and people with serious criminal records and recent entrants. And if you don't fall under those, then ICE should exercise prosecutorial discretion and dropping a case or releasing them from custody. And that's kind of what we did here. We got ICE to release someone because he's not a priority, and that's what happened here.
So the last case, we also have a client who we get her status and then we bail her out from the ICE detention, right?
Yes. we used a status that we got from USCIS to convince ICE to release him. Well, not convince, we forced them to, because they can't hold someone with status in detention. We were talking earlier about U visa, how you can apply for it even though you have a removal order, and that's what happened here. This person was arrested by ICE during a worksite raid and then was threatened with deportation. However, what we did was we applied for U visa because we discovered that this person was eligible for U visa through her husband. We expedited that U visa, and this person was in danger of being put on a plane because ICE had her passport. So they didn't even have to wait for a travel document. They could just put her on a plane. But we acted fast. We filed the U visa fast. We got a really quick determination on the U visa via their husband. And then when we got that, we told ICE, hey, this person has U visa now. Can't remove her anymore, release her. And that's what happened.
Yeah, we talk about a lot of case. And if you have your own problem or your relative have their own problem, you should call in to consult, or you can leave your question with any of our platform.
Right. And, we talked about a lot of our previous clients, a lot of scenarios in this case. But at the end of the show, I always like to remind everyone, whatever I say here is based on my legal experience and my legal opinion. It is not legal advice. It's not advice specific to any one case. Every case is different. So if you want advice for yourself or your family member, I highly suggest you reach out to us through any of our platforms. At the same time, YouTube shows like this does not constitute legal representation. Just because you're watching this doesn't mean that I'm your lawyer or Wang Law Office is your lawyer. But if you want us to represent you for your immigration matters, please reach out to us through any of our platforms.
And you can continue follow us on YouTube. We'll be back again next week with another show, Friday at 11 a.m. EST and 8 a.m. PST. See you then.
Bye.